clerk will open the court. Excuse me. The clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals is now in session.
Good morning. The COVID-19 pandemic required many adjustments of the justice system. Social distancing and group size restrictions, as well as substantial hardships on counsel traveling to Austin, do not allow us to hold arguments in the courtroom. Rather than submit cases without argument, we have decided to proceed through remote connections. Court staff has made every effort to prepare us and counsel, but of course there may be glitches that will require patience. Otherwise, we will proceed as we would in person. The arguments are being live streamed this morning, and a recording will be available later today. We're ready now to hear argument in cause number PD-1070-19, Robert Lee Crider Jr. versus the state of Texas. You may proceed.
Thank you, Your Honor. May it please the court. My name is Pat McGuire, and it's my honor to appear before the court today on behalf of Mr. Crider. In preparing for oral argument today, it occurred to me that Mr. Crider's arguments could be boiled down to two fundamental questions. The first question would be, did the Supreme Court mean what it said in the Skinner case when it said that a chemical analysis of a biological sample constitutes a search? And the second question would be, did this court mean what it said when it stated last year in State v. Martinez that a chemical analysis is a search? And this
counsel, one question I have, this is a search based on a warrant, right? I mean, there is a warrant involved in this case that sees the blood, right?
That's correct, Your Honor.
Right. So the same evidence that was used to justify the seizure of the blood is going to be the evidence that's used to justify the search of the blood.
That's correct.
So
and I'm sorry.
Well, I was going to say, so all you're really advocating for is an extra line in the warrant form, search and seize and search the blood?
Precisely. That's precisely what we're arguing. And the reason for that is the verbiage in both Martinez and Skinner. And this court has what I'll characterize as two different lines of cases dealing with this. One is the Hardy-Hughes line of cases, which deals with an expectation of privacy in medical records and blood that has already been tested by medical personnel for non-law enforcement purposes. And we're not dealing with that. I think the court correctly held in that case that there was a lower expectation of privacy in that regard for obvious reasons. The blood has already been tested, and in those cases, what the state's wanting are just the results of the blood test that can be obtained through either warrant or grand jury subpoena, whatever legal means there would be. The second line of cases, which we're dealing with here, we go back to the Comeau case, and I believe I'm pronouncing that right, but the Comeau case, which was a plurality opinion. And in that particular case, the court indicated that there was an expectation of privacy in a person's blood sample from testing. And the court
But counsel, isn't there a distinction to be drawn between these medical record seizures based on a grand jury subpoena? That's that Hardy-Hughes, Comeau case, and Martinez, which dealt with absolutely no warrant whatsoever. The police just seized it, and they didn't have a warrant.
Well, you're correct, Judge Newell. That's one distinction, but the other distinction is here we're dealing with the case where the government takes the biological sample itself, and there's two fundamental searches at play here per the Skinner case and per the Martinez case. One is the initial drawing of the blood, which clearly is there's an expectation of privacy. But secondly, and what Mr. Crider's focus is in this case is on the analysis of the blood. That opens up a whole different can of worms, so to speak, because the warrant in this case didn't say what the state could do or couldn't do with the blood. And
isn't there always a presumption that when the state is drawing blood, I mean, everyone understands that when the state's drawing blood, it's going to also be tested.
That's correct, Judge Slaughter. But this is the problem. The warrant serves as a floor. Of course, it's implied that the state is going to test for blood, but the warrant doesn't put any constraints on the state. It doesn't say what the state can't do with the blood. And that's a fundamental concern. And that brings into play the Fourth Amendment's prohibition against general search warrants. In this particular case, what we have is we have a clear directive from the United States Supreme Court and from this court saying that analysis of blood is a search under the Fourth Amendment. Therefore, the next step that comes into play is when we have a search warrant, and I'll agree with the state, a common sense reading of a blood search warrant would suggest that the state surely can test for alcohol. But does it say that the state cannot preserve that sample of blood and test it for other things down the road? In this day and age, that is not a far-fetched concept, and those are the exact concerns that were raised by the United States Supreme Court in Birchfield versus North Dakota. And if the court, I think it's Maryland versus King, which was a 2013 United States Supreme Court case that dealt with buccal oral swabs that were being done by the state of Maryland on everybody who's arrested. And Justice Scalia's dissent in that case encapsulates perfectly the concerns that we're faced with here. Because when we're dealing with blood, we're dealing with a very unique subset of evidence within the greater taxonomy of evidence. Because at this point, when a person's blood is drawn by the government, the person from whom the blood is drawn may not even know all the facts that blood can tell. There may be physiological information, genetic information, a whole host of information that if we're going to say a warrant implies the state to do something with that blood, what we're essentially doing is we're making the state, the government, law enforcement, the arbiter of what is implied and what's not implied. And clearly that is anathema to our Constitution. In our reply brief,
but wait a second. In Maryland versus King, there was no warrant either. That's part of the big beef, was that you not only did you not have a warrant, you didn't have any reason to believe that these people had committed a crime. That's different than the police going to a neutral magistrate, getting a warrant based on the same facts that they would use to justify the search. This isn't this kind of general warrant situation that Justice Scalia was concerned about. This is police basically trying to do what they're supposed to do, which is, let's not make ourselves the arbiter of it. We're going to go to magistrate, see if these facts show a reason to believe that there's evidence, and we're going to seize.
Well, and I would respectfully disagree with that statement on a couple of points. Number one, in King, the buccal oral swabs were taken from people who had been arrested on quote unquote serious crimes. I think that was the category that was used. And some of the distinctions that the court in that case used to justify those searches were the fact that a buccal oral swab is not very invasive. It's not like sticking a needle in somebody and drawing blood from them. But secondarily to that, the information that could be derived from those oral swabs, the court said, is just identity. That's all it's for. Therefore, we're going to uphold that. In this particular instance, and I would agree with the court that when the warrant is obtained by the magistrate, the blood warrant only authorizes that first search, which is the drawing of the blood. It makes no statement or reference to the second search, which is the testing or analysis of the blood. And that is the focus here. And what Mr. Crider's argument here is, in essence, what we have is a general search warrant, because blood is unlike most other evidence. Blood can't be drawn and a physician or law enforcement officer can go, aha, there's the blood alcohol concentration. Let's just draw that out of the blood. That requires testing. And therefore, if the state can test for alcohol and there's no restraints on what else the state can do with that blood, truly, there's nothing keeping or preventing the state from putting that blood into a DNA database and keeping it for whatever purpose they want to. That's the essence of our argument here, that basically authorizing just that first search, but not putting any guardrails in place as to what the state can do for that second search, is in essence authorizing a general search warrant.
Counsel, the probable cause affidavit will discuss the purpose of the blood draw being that the blood has evidence of intoxication. And so that does put parameters for what can be tested.
Well, I would respond by saying that's in the probable cause affidavit, The warrant itself is the judicial authorization for law enforcement to do what that outlines the boundaries of what law enforcement may do and may not do. And in this case, if the court sets out a rule and says, well, it's implied that the state can do this, well, the state then becomes the arbiter of what's implied and what's not implied. And that's the essence of why we have specific particularized search warrants under the Fourth Amendment.
Okay, counsel, but that's kind of exactly what Judge Slaughter is saying, is that this isn't a general warrant where they're trying to find stuff because they don't have a targeted crime. This is part of an investigation, an ongoing investigation where they are targeting this defendant because they have reason to believe that he's committed the offense of DWI. And so they have reason to believe that there's intoxication evidence in his blood. So that's different than a swab where you're going, well, I've got this swab and then I'm going to go look and see if I can pin another crime on the guy based on the swab. This is the police actually engaging in an investigation and getting a warrant to do so.
And I agree wholeheartedly, but there's no legal justification why the warrant should not specify that the blood can be tested only for evidence of alcohol or other intoxicants. Therefore, by implication, if that warrant says that, it sets out crystal clear guidelines to law enforcement what it may and may not do with that. And again, these are, yes.
But if we carry your argument to its logical conclusion, every warrant would say, and you may run a test on this, but you can't retain it. You can't make it part of a database. It would set out all the things you couldn't do according to you because it needs to be that specific. And that's what you're trying to keep it from doing. Well,
if I may respond, I see I'm almost out of time for my opening argument.
Yes, please respond.
Thank you, Judge Keller. What I would respond with, Judge Kiesler, is that if there are, right now, there's no guidance in the warrant itself, not the probable cause affidavit, but the warrant with what law enforcement may do with such a sample by specifically stating what the government may do with it. By implication, that excludes what it can't do with it. And so I don't think a warrant needs to contain all of that other language. It could, but I don't think it needs to. I think I'm out of time at this point.
Thank you, counsel.
Thank you.
May it please the court, John Messinger, Assistant State Prosecuting Attorney for the state. Stripped away of everything else going on here, this is a case about the admission of evidence. And a quick test to see if you're doing the analysis wrong is if you're talking about everything else other than what the state was trying to offer. The state offered and was admitted appellant's blood alcohol content. The Supreme Court in Birchfield says he has no privacy interest in his blood alcohol content. The state obtained that sample to do the tests with a warrant, and appellant's not contesting the probable cause underlying that warrant. So he literally has nothing to complain about. All of the conversation about whether or not the warrant implicitly covers this, I of course believe that it does because there's no other way to read it. But when you get down to it, you can't be talking about all of the bad things the state could have done, but didn't do in this case, when you have no real Fourth Amendment complaint. This isn't a court of general jurisdiction where you're going to remedy even actual harms. I mean, if DPS had the time and resources to be running tests that have nothing to do with a criminal trial, you could sue them. Maybe you'd win, I don't know. But this court, and no criminal court, has any power to say, this blood alcohol content was obtained lawfully. However, we don't like other stuff that we hear that you did. So we're going to teach somebody a lesson. Because again, the only thing—
Counsel, what is to prevent the state from using it for other purposes?
What
is there any restriction at all?
If you're talking about the warrant, if you're going to skip to, we need this warrant to authorize the search, which I disagree with. But you look at it and you say, the warrant said, go get blood because we think, and I agree with you. The magistrate says, I agree with you, officer. There is probable cause that there contains blood alcohol content in this blood. Go search or go seize if you want to parse out whether or not getting blood is searching or seizing. All you have to do is say that's obviously what it allows. and all that it allows. You can agree with the 3 other courts of appeals in Texas and every other court in the states that have covered it across the country. When there's a warrant, and this is not just with blood, this is going back decades. When there's a warrant that says, I agree with you, officer, there's probable cause this person has kiddie porn. Go take all of his books and film. Well, the courts have said, obviously, if there's undeveloped film, you have to develop it. If a magistrate says, I agree with you, officer, there's probable cause that he has fraudulent bank records in his computer or on his diskettes. Well,
is there any distinction though, when you're talking about kiddie porn, they're saying seize the kiddie porn. Here they're saying, here the warrant says seize the blood. It doesn't say seize the blood alcohol content. It doesn't do the analysis. I mean, to some extent, why shouldn't we look at this as, you know what, this is an easy fix. The state should have just included that extra language in the warrant.
A win, lose, or draw, I think that everybody across the state is going to be fixing their warrants to say that. The question is whether or not it's necessary. And in the cases I've talked about, in the cases I've cited in my brief, it's not that the judge said, I agree there's kiddie porn, so seize kiddie porn. And in fact, in those cases, you have defendants complaining that officers flipped through everything, that way they could only seize the kiddie porn.
Let me just ask you, Mr. Messenger, are you of the opinion that once the blood is drawn, in this particular case, beyond the scope of the DWI information in the affidavit, the state has any limits on how they can use that blood?
Yes. If the question is just based on the warrant, then the warrant implicitly has a limitation. It's an authorization and a limitation.
So in other words, could it wind up in a DNA data bank, like a CODIS? Could they take the blood, analyze it for DNA, and put it in the CODIS system without an additional warrant?
Not without violating the warrant. I mean, this is the thing. If the question is whether or not something bad could happen that wasn't authorized by a warrant, that happens with better drawn warrants. Potentially, if we're going to wring our hands over what could happen if the blood is not immediately returned to the defendant after it's tested for a single thing. And I'm not trying to be cynical about it, but at some point, the limitation has to be, what is the judge authorizing, just based on plain reading? And it seems backwards to be so obtuse about reading this warrant to say, well, I don't see any implied limitation. So you write the implied limitation out, and then we wring our hands about how this is a general warrant dreaded by the founding fathers, and it's nothing of the sort. But again, I come back to the idea that we can fight over whether or not in this case, in this warrant, we have a problem based on the grammar and this court's implicit ability to interpret warrants to figure out if it's reasonable. We're not leaving it to peace officers.
So counsel, does the warrant, if the warrant just says blood alcohol, but when they run the test, it shows drugs, can the state use that? Or are they limited to looking for alcohol and not just anything that shows he's guilty of DWI?
If the only thing that the officer is asked for or alluded to is, I smell alcohol, I think he's intoxicated, that's what it would be limited to.
But that, actually, the question I have though is, we have plenty of warrant cases where the police say they have an order, or the police have an order to search, and as long as they find stuff in that area, where they were looking for the evidence, they can still use that. Why wouldn't you then be able to say, I can do this CODIS analysis or this DNA analysis because I'm doing an analysis? You know, I'm allowed to search the blood.
Well, see, and again, this is the problem with the conversation and combining it to the warrant issue as opposed to the expectation of privacy, which is normally how we do a Fourth Amendment issue. But I'll go with your example. If this were a house and you got a warrant to say, I agree there's probable cause that there's a stolen diamond ring in the house. We accept the fact that under modern technology, a human being would walk through and open up every container where there might be a diamond ring. And it is impossible to tell officers, of course, you can go search in the nightstand, but just don't notice marital aids. Don't notice anything else embarrassing. Just only see the diamond ring. Blood is different. We can talk about how blood is special because it contains all this other information. But right now, we can't shrink down, walk around through blood and just say, oh, there's alcohol. Oh, there's some AIDS. It just doesn't work that way. you have to run the one test that only reveals blood alcohol content. If you don't accidentally run a test that reveals something other than that. So, and because it should be a greater conversation about what is the interest, rather than what does this warrant grammatically authorize. Much like your blood alcohol content, you have no legitimate interest in privacy in. You have no interest in whether or not you have cocaine in your blood or anything else. Again, this is a Fourth Amendment issue. We're doing this all backwards based on a large policy conversation. The policy conversation's been had. You know, this court and opposing counsel want to pull from Birchfield the things it wants to pull. And I don't disagree that blood has a lot of stuff in it. But what Birchfield says is when it comes down specifically to blood alcohol content, and this is citing Skinner, so this isn't a new concept, you have no significant interest, a privacy interest in that. And when you come to court and you say, I don't want my blood alcohol content coming in, the first question is, what is your interest? What is your Fourth Amendment interest in your BAC? And it's nothing. The best you could possibly do is say the state unlawfully got my blood to do that. But you can't say that in this case because they did it with a warrant. He has nothing to complain about, and this case should not be decided on, although it could be in the state's favor, shouldn't be decided on whether or not this warrant implicitly authorizes and limits only blood alcohol, which it does, but that doesn't advance the law as much as what I'm talking about.
Let's just assume it's not blood alcohol. It's methamphetamine or marijuana or cocaine or something that would impair his driving ability. Is that going to be admissible under this type of warrant?
It would be admissible because he has no interest in privacy in it.
Okay.
Like he just doesn't. We get caught up in a conversation about all the things that could be in blood, and we look at Birchfield because Birchfield is a case about whether or not we should just do, as a matter of law, search incident to arrest. If you're arrested for any reason, is this going to be like turning out your pockets? Do we just get to rummage through your blood? And they said no, for lots of different reasons. But along the way, they said, just because you can't do this generally doesn't mean you have an interest, a privacy interest in your blood alcohol content. You just don't. And again,
so is it your position that anything detected in the blood that would impair the driving would be admissible, but beyond the scope of that, it would not be admissible, such as DNA testing or things like that? Or do you still think the DNA testing would be admissible?
No, I at this point, I have no idea what sort of DNA they could find that would prove that you were impaired under the law.
Well, we don't even need to get there because what's happened here is that it was seized, and it was seized for the very reason that it was used. And so it seems to me that that's really kind of as far as we need to go, isn't it?
Seized for what it was used for. They didn't do anything else, and it was tested for something he has no interest in privacy in. I mean, I really think this is an easy case.
How important is, counsel, how important is it though, is the language in Martinez that says that there's an interest in the blood content, there's a separate analysis for the blood content? Or was that just not necessary because the case only dealt with a search warrant, with the lack of a search warrant or seizure warrant?
If you need to retain Martinez on some level, you can go back and you can try to make it not about privacy interest, which Birchfield did away with, but try to say you can distinguish it on the idea that the state also obtained it without a warrant. But nothing about Martinez talks about a defendant's property interest in his blood. I don't know that it would be practical, and frankly, it would be gross to say that anytime you give a biological sample, you've created a bailment arrangement where they have to give it back to you. So I just don't think that you can support Martinez in light of Birchfield. Because
so you're affirmatively telling us that we have to disavow Martinez?
If you just want to go on the warrant, if you just want to say this is an easy warrant case and we're going to read it in a common sense manner, you can sidestep that entire issue. That would be the quickest way to do it. But the best way to deal with a Fourth Amendment issue is to ask the fundamental Fourth Amendment question, do you have an interest? I don't know how you go back and you look at Martinez in light of Birchfield saying that there is no expectation of privacy in blood alcohol content and say there is. And the problem with Martinez is that it follows the model, broadly speaking, of Birchfield, which is it's an abstract conversation about interests, which of course there are lots of abstract interests in your blood. Much in the same way, there are lots of abstract interests in the contents of your house. But if the evidence we're trying to offer was found in plain view in open fields, it really doesn't matter how much other swell stuff you have in your house. And that's the problem. And it's interesting because Martinez breaks from Hardy in that manner. Hardy ends up by saying, regardless of what other interests you might have in your medical records generally, you don't have an interest in your blood alcohol under these circumstances. So Martinez is the aberration. I'm asking for a return to Hardy. Whatever else might happen if somebody did something bad with the blood, which no one's even alleged that they've done, you don't have an interest in this particular fact. Your only possible ground is to say they can test for it, but only if they got it lawfully. But in this case, that's all we have. And in fact, this warrant could have just said, seize his blood. And the only criminal law Fourth Amendment issue we would be asked is the thing that he's asking to be suppressed something he has an interest in? And the answer is no. And again, if you have to make the conversation about all the stuff that didn't happen in your case, you're probably not going to win that suppression issue. If there aren't any other questions, I'll cede the rest of my time.
Thank you, counsel.
May it please the court. In response to the state's argument, the state would not even need a warrant to draw blood, because if it's implied that the purpose of drawing blood is to look for alcohol, then why even bother with the warrant for the first search? That makes no sense, and that runs countervailing to what the United States Supreme Court has said. And here's the other statement or argument by the state I would like to respond to is the state seems to suggest that, well, because there was nothing else tested for here, there's no harm, no foul. Well, that's not how we analyze constitutional violations. The whole purpose of having a warrant requirement is to ensure that the warrant meets the particularity requirements set out by the United States Supreme Court and by this court. And the penalty is not whether they found anything bad or anything they shouldn't have. The analysis kind of goes like this. You look at the four corners of the affidavit, and if the four corners of the warrant, and if it's insufficient, state loses, period. There's no further analysis beyond that. And the state seems to argue that, well, it's implied, the warrant, and I'm focusing on the warrant, the piece of paper that's handed to the officer to go get the blood, that it's implied that they could test for blood. And I would put the question back on the state, where does it say it in there? There's nothing saying what the state may do or may not do. And even though the state wants to characterize this as something, I'm sorry.
No, I was just wondering, how do you respond to the state's argument that Birchfield says there's no expectation of privacy in the contents of blood alcohol analysis?
Thank you for that, because Birchfield also made a very critical distinction between breath tests and blood tests. I would agree with the state that there's no meaningful expectation of privacy in the contraband, but that doesn't mean that the state can go in and kick somebody's door in without a warrant because they believe contraband is within the house. In this particular case, what Birchfield has said, and they drew this distinction clearly, and I believe this court even mentioned it in its a Martinez opinion, that a breath test, the only thing you can get from a breath test is alcohol concentration. That's it. There's nothing else. But the Birchfield court laid out the litany of information that can be obtained from a blood sample that you can't get from a breath sample. And so
doesn't that though depend upon what type of a test you subject the blood to?
Yes, and therein lies the problem. Who decides what tests are going to be done? In this case, if there's some warrant that says they can just draw the blood, there's not, basically what we're doing is we're saying, police officers, you police yourselves. We're going to trust you to do the right thing. And I don't think it requires any sort of citation. You know, our founding fathers didn't found this country on a trusted government. It was on a mistrust of government. That's why we have a constitution. That's why we have the judiciary to lay out crystal clear guidelines on what the state may and may not do. And if we're going to start saying that, well, it's implied in this warrant, that's a slippery slope. The statement in the Martinez opinion, I counted no less than 11 times where this court acknowledged that the analysis of blood is a separate search discrete from the state's drawing of blood. Now that means something. And if there is a search discrete from the state's drawing of blood, there has to be some warrant expressly, not implicitly, but expressly authorizing that. That's the essence of the argument. And balancing that against the burden it would put on the state, the burden put on the state would be minimal. All we need to do is add one other sentence into our warrants. The problem is solved because it's crystal clear what the state may do and may not do with that biological sample. The other point I would like to touch on, if I may, in response to the state's argument that, well, there's these other courts in other jurisdictions that have just held a warrant authorizing the drawing of blood impliedly authorize the testing of blood. Well, I've read each and every case cited by the state in its brief. And in each and every case, one of two things happens. There is no mention of Skinner, no attempt to wrestle with the dictates of Skinner, which say that an analysis of blood is a search, or two, and this particular case is State versus Randall. It was handed down by the Supreme Court of Wisconsin. They got the Skinner holding wrong. They said that Skinner suggested that drawing and testing are one continuous search. And that's clearly not what Skinner said. And that's not what this court said Skinner said. And so basically what we have in some of these other cases is bad precedent begetting more bad precedent. There's no meaningful analysis in those cases to justify how you get around the Skinner statement. And I would suggest Birchfield as well, because Birchfield drew a clear distinction between breath test and blood test. And it was based on two factors. One, the intrusiveness of obtaining the evidence, and two, the quantum of evidence or the quantum of information that could be obtained from each separate sample. So when the state's suggesting that there's no expectation of privacy in a blood alcohol concentration, therefore Mr. Crider loses, well, it ignores how you go about getting that blood alcohol concentration.
Isn't your case distinguishable from Martinez on the basis that there actually was at least one warrant involved versus the Martinez case where, you know, the police did not obtain the blood by virtue of a warrant, and then they went ahead and tested it without a warrant?
Well, I think it is distinguishable, but I think that does not have any distinction here, because if you look at the analysis of two searches, and in Martinez, this court expressly stated that any testing of a blood sample that was obtained by the government is a search, crystal clear. So that begs the question, how do you get around having a warrant expressly authorizing that search? And that's really the essence of the argument.
So would you be okay if the warrant said you're going to test for any evidence of intoxication so they could look for both alcohol and drugs?
Yes, I would. I think that would be well within the purview of law enforcement, but it would also set the boundaries that law enforcement, what they can do with that. Because the penal code, section 4904, just says that a person is in violation of that statute if they're operating a vehicle as a loss of their normal mental and physical faculties by the introduction of some intoxicant. So I think that would be perfectly acceptable. But my point, Mr. Crider's point, is that there has to be some limitations on what the state can do with that blood, or otherwise there's no limitation on what the state can do with that blood. So in closing, what I would argue respectfully is that circling back to the original two questions that were posed at the beginning of the argument, did the Supreme Court mean what it said in Skinner, and did this court mean what it said in Martinez when they both courts stated that the analysis of a biological sample by the government is a search? If the answer to that question is yes, then the answer here is crystal clear. Mr. Crider should prevail because the warrant in this case was a general search warrant and did not authorize the testing of blood. If there are no other questions, I would cede back the rest of my time.
I just have one question. Do you concede that the state did not exceed the scope of the information they were seeking based on the affidavit? And that is, they didn't go beyond anything
Correct.
beyond alcohol. Okay.
There's no evidence of that.
Okay.
Thank you, counsel. The case is submitted and the court will stand in recess.
Thank
Clerk
you.
will adjourn the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals now stand recessed, subject to the call of the presiding judge.